All right, 20.5, jurisdiction and venue. So, a debtor can file for bankruptcy in the district where the debtor has resided or has a primary place of business for the preceding 180 days. So, you can't just move to go to a different bankruptcy court. Where we're at, you would file in the United States District Court for the District of Maryland. But this is a federal court filing. It needs to be done on the federal level. There are some consumer protections and debt relief things that can happen on the state level, but bankruptcy itself is a federal law, federal process, has to go through the federal courts. Okay. The bankruptcy courts and jurisdiction. So, bankruptcy court is a separate part of the federal courts. Okay, so people who are in bankruptcy practice as a lawyer not only are licensed to practice in front of the federal court, but they also usually have some sort of special certification that allows them to practice within the bankruptcy court of the federal court. There's a bankruptcy judge. That's the judge that presides over all of the bankruptcies. There's a clerk. There's a Chapter 7 trustee. So a Chapter 7 trustee is appointed when the bankruptcy proceeding starts. That person is required to recover, ascertain, find out all of the non-exempt assets that that a debtor might have. You know, if you own a bunch of property or something like that, then your creditors could have access to that, and the trustee is responsible for figuring out what those assets are, and then figuring out if there's a way that those can be liquidated to pay or satisfy some of the creditors. Okay, there's a United States trustee. That is the person who is appointed by the Justice Department. It just kind of monitors bankruptcy, so they're making sure that the process is moving forward and is efficient. And then there would be a Chapter 13 trustee. So Chapter 13 trustee would be the same as the Chapter 7, but for specifically Chapter 13 bankruptcies.